And I will, Brad Vandervet will be assisting here to help unmute folks as needed and doing some of the background work here for Kendra, who's not able to make it this morning to do that work. Okay. Before we start, Olivia, did you have anything to comments, updates? Maybe you can introduce Mr. Small.
Well, I think you all know Bob Small. He is taking over for Andrea, who was appointed to the bench. And so thank you so much for doing that. In terms of updates, we don't have anything at this point that I'm aware of. I have sent everything out that I have available at the moment, and I am continuing to do research into the 2005 changes as were requested during the last larger group meeting. Other than that, no.
Okay, so this is the requirement subgroup. Some of the areas that you will be focusing on, but as people have noted, some of them bleed over into other areas, but extensions of the registration periods is one of those areas that we look at. Both, two of those issues are when 5 years is added for failure to register, and then restart of the registration period for incarceration periods. Another area that is covered in this, where there should be focus, are the collateral consequences. And those include additional things that apply or affect someone because of that. And Angie put together a good list of some of those statutory things that affect someone based on their registration status, something that has plenty to review that entire list, and Angie and others might be able to clarify any questions on that list. And additionally, those other collateral consequences that have been brought up were the residency restrictions based on registration status or risk level assignment. So with
I was just going to say the list I did is obviously just the statutory collateral consequences. I don't have anything else in my list.
So any of the chairs, do you have any areas that you wanted to kick off in this discussion or focus on at this point?
So I'll go. I haven't spoken to many people yet today, so my throat is a little rough. Olivia, you were working on getting the 6-pager, the form
Yes,
that ACRA registrants get.
Yes, it is still being watermarked. We need to make sure that it can't actually be used once it leaves the building.
Okay, is that the form that they fill out, or is it just the instructions?
The instructions are on the form that they fill out, so it is both.
Got it. Okay, so I had asked Olivia for the form that if some of you heard Luis's short presentation at the main working group last week, he talked about this form that the registrants get, which is 6 pages, 11-point font, and very dense. So we thought I thought it would be helpful if we actually saw what that looks like, because I've never seen it. And then I guess I'm just looking back at what we talked about last week and trying to kind of put some buckets around this content. One of the things that we talked about last week was the extension of the registration period on the 10-year, for the 10 years, which would be subdivision subdivision 6, paragraph C, which is if a person required to register is incarcerated due to a conviction for a new offense or following the revocation of probation, supervised release, or conditional release, that person will continue to register until 10 years have elapsed since last release from corrections, or until that probation, supervised release, or conditional release expires, whichever is later. And we were talking about, is it any offense? Is it any new offense? Is it a DWI? Is it disorderly? The important thing to remember is that it does require incarceration, or the revocation of probation, supervised release, or conditional release for any offense. So that's a lot to think about, but it's pretty important. I don't know if we have any data on, I have to be honest, I'm losing track a little bit of the data requests. I feel like I need a spreadsheet put together of what's been, what's been requested, what's been fulfilled, where are there gaps, what does BCA just not have to just track. But, and if we have asked for data on this, or if I have asked for data on this, I feel like I have, this seems familiar. But I think that's a really important one to talk about because it's so significant to, like we talked about, for a person to be in year 9 of their registration period. And then, our worst case scenario is, something goes wrong, which is not a significant offense, but it is an offense that lands that person, requires incarceration, and then the person's on for another 10 years. So I'd be interested in hearing from people about what some thoughts on that, or if people are still feeling like, yeah, we need to run this down and think about this.
So one really quick thing, we wanted to share the form while we can in front of you, because this is the next best thing to getting it to you right now. This is ADA compliant. Here is what the form looks like. So they received the Tennyson warning as is required. Previous addresses. Primary address. Homeless number. And one other thing that we should note is that all of these items are required by the statute. So this form is in compliance with all of those items. Employment information, school, emergency contact, vehicle. Now, please note that some of these sections are to be completed by the actual registration official, whether that is the corrections officer, whether that is the law enforcement official that's at the desk when you come in. So a number of these are required to be done by that. Again, all of this offense information is not for that individual. That is for the actual person at the desk. Again, all of this, again, by the registration official. Then duty to register. Here are all of the requirements that we have to make them aware of. All they need to do is initial here. And that's it. So about half of this is required by the actual registering official. The other items are, basic address, vehicle, school, employment, etc. All of which are required in statute. And I believe the last update to this was, well, we update them every time that the statute is changed, but the most recent addition was, I believe, for homeless offenders. And there needed to be that section. So that is the form, not 11-point font. Half of this is provided by the actual registering individual, and the remainder are all required by statute.
Did you say it's not 11-point font?
Correct. It can't be 11-point font for it to be ADA compliant.
Oh, okay. Maybe there's a perception that it's 11-point font then.
Yeah, no, we have to comply with ADA standards when we're coming up with forms, and so this is all ADA compliant.
Okay, thanks for that.
Yeah.
Then you can just send it out and we can take a look at it closer.
Okay.
Oh, quick, I thought we were done. I just sent it.
Okay, Patty.
It's hard to take it all in quickly. But I have a question on, do they get that same form, if they're rearrested for another crime and get incarcerated and then get out again, do they get that same form? Just like starting over?
Hi, Patty, this is Katie talking. That registration form is only completed, again, if they have a new conviction resulting in registration. Otherwise, all other updates would be done on a change of information form.
But
Can
I'm
you send that
confused.
to, sorry.
Yeah. I'm sorry, Patty, I couldn't hear you.
Well, that's where I get confused on what all is included in that renewed requirement to, as I understood it, you get arrested for pretty much anything and then incarcerated, that's going to require a new 10 years or whatever. Is that right?
Well, resulting in a conviction, there has to be a conviction. Somebody that gets picked up and is on a PC hold over the weekend and never charged or convicted of a crime, that wouldn't restart. But we don't require a registration form for a DWI conviction. The registration forms are specific to an offense requiring registration. So you'd have to have another, let's say another CSC court case and a conviction on that. Otherwise, it would just be a change of information going in or out of the jail.
Okay, perfect.
And then maybe the other piece that you might be thinking of too is that the annual verification form. Offenders will get that once a year, but that's just giving them all of their current information.
Okay. Thank you. That clears up a question. Thanks.
Sheriff Heck.
That went by kind of quickly. It looked like there were about 20, if I remember, there's about 20 things that they have to initial. But to kind of break it down, aren't we basically telling them that you have to remain law abiding? You have to tell us where you live. You have to tell us what vehicles you drive, where you work, where you go to school.
Yeah, it's not an all-inclusive form. I mean, we don't go down through every single, piece of information in the statute, but we pulled out the information that would help the offenders along with based on what they're required to provide and what may impact their registration period. Yes.
Right, but I guess my point is that it seems we don't seem to be asking, in my opinion, a lot of them. Register, be law abiding, tell us about these things that the law requires you to tell us about. And one question, just to clarify for me, is it the period restarts for any conviction requiring any incarceration, or does it have to be more than a year and a day?
Great question. No, it's for any incarceration. So prior to 8/1 of 2014, the sentence had to be served subsequent to the conviction. After 8/1 of 14, credit for time served. As long as there is a sentenced period of time, whether it's a day or 2 days or 20 years, whatever it might be, as long as they are given a sentence, requiring incarceration.
And as to your question regarding the requirements, I mean, this is essentially all of the things that they need.
Can't hear
Your
you.
sound went out.
It says things like, I have to return the verification form. Or I understand that I have to provide my secondary address, my primary address. So they're pretty much just reminders of the registration and the things that could impact it. But these are all things that they need to do regardless of whether it's on the form or not.
And I've had to go through this form with a few offenders, and as you pointed out, most of that form is completed by the registering official. And so that offender, at least in my practice, it's been, they come in, they meet with me, and you go through that list of things and ask them if they understand that. So it isn't like you're just sending them this piece of paper and saying, good luck to you. There's a probation officer or a police officer or somebody that's going through this form with them that presumably knows what those requirements are.
Yes, and that's exactly why we are going to have that watermark on our forms, and we never mail out changes of information to offenders. We don't mail out the registration form because the statute requires all of these papers to be completed in person with law enforcement or their corrections agent. With the exception of that verification form, but like Sheriff Heck said, if if 1 year later you're going to get a verification form, it's going to have that duty to register. Yet again, telling them, any changes that were made in the statute and reaffirming basically what you read as a law enforcement official to the offender.
Thank you.
Okay, Angie.
Well, so I was just gonna say, I mean, it seems to me kind of the two questions for this group on this particular part of the statute is, do we want people to do we want that period to restart for 10 years for any offense? Or do we want to limit the offenses? Like, let's say they have to be reincarcerated for a registration offense or commit a new registration offense. I mean, to me, it seems like, or do we want to like shorten, leave it applying to any incarceration, but shorten that somehow? But that's what it seems to me is kind of the question is should somebody who's in their 9th year and gets a disorderly conduct be required to register for 10 more years?
Patty.
I'm just going to speak as a layperson. You all are functioning in a world that many of us don't know. And so if it's a first-time offender and suddenly he's getting all this stuff, it doesn't matter who it's filled out by. It's kind of like going to a medical appointment and you've got a surgeon telling you stuff that you just don't quite get because you speak a different language, and it's all very familiar to those of you who do it. But especially a first-time offender, it would be mind-boggling. So I guess we need to hear that side and make sure that they're given something that really is clear and not legalese and not court language, because I think that's what I heard from him. Clearly, it is mind-boggling, and I think that I agree with Angie. We need to address two pieces. I think, what is going to be the reoffense, but I also think that the clarity of what does this mean to me, and really, so they walk away knowing that there's 6 pages was filled out by somebody else, so they probably don't really have time to absorb everything that's on there because they didn't fill it out, which is a good thing. I'm just trying to share a perspective, because I never went to court until 5 years ago, and I was like dropped in a different land. I didn't understand any of the language, even though the words were, and they asked, do you understand? I really, I appreciate somebody, especially a first-time offender, walking away, even though you've said everything absolutely clearly, not getting it. Just had to share that.
Chris,
Just on Stacy and Angie's point from earlier, I think you specifically mentioned DWIs. Yeah, the way this reads right now is a second DWI in 10 years would trigger another 10-year registration, and that seems to be an offense where there would be really no nexus between the registration offenses and the conduct leading to a second DWI. So it does seem for this subdivision 6C, there's some opportunity for some clarity to narrow that new offense language if we're sticking with the stated purpose of the registration statutes.
Katie.
Thank you, Mark. Just to speak to both Angie and Patty's points there, just giving the whole duty to register, Patty, that was why we put that in. Back in the 90s, we didn't have that long list of what the statute required, because all it required was their primary address. And so over the years, the point of the duty to register is to try to make a little more sense to somebody filling out the paperwork, as well as like all of us that have to, go through it, make that statute more clear. And so that's the point of that duty to register. It's trying to take that legal information and put it into context that could be more easily understood by everybody involved, from us working in here to those filling out the forms to the offender, everybody involved. So just speaking on that piece, we tried to pull that legal format of, the average person doesn't understand if we don't have a law degree. The other point that I wanted to speak to was Angie's, had mentioned, like, do we specify the crimes? Do we say it's only for another registration offense? I just want the group to know that was how it was up until 2005. From 2000 to 2005, it only restarted for a new registration offense or a violation of the offense for which they were registering. And then they opened that. So I don't know what the intent was back then, other than I have heard. That was my lull of not being in POR for a couple of years there. I had heard that the intent was looking for 10 years of crime-free behavior, but.
Angie.
I actually was going to ask Katie if she remembered what that history was. So, and that probably, based on what some of the cases have said, it probably is looking for that 10 years of crime-free behavior in the community. But what the significance of that is, or what that's based on, I don't know. And from the standpoint of what makes sense for the registry, I don't know if that is helpful or not.
Representative O'Neill.
Thank you. So I went back and listened to the committee hearing. I believe it was from 2000. Rich Stanek was the chair of the Public Safety Committee, and we had an officer from Minneapolis come and testify. And it was at that time that they were changing the penalty for non-registrant, for not registering or keeping up with registration from a gross misdemeanor to a felony. And the reason that they asked for that change is because only 35% of those, I believe in the city of Minneapolis, were in compliance. So that's obviously not very helpful. That's a lot of people flying under the radar. So I guess my question would be to the BCA, and since we're talking about violating and getting another 10 years, how many people are in compliance now compared to 35% in 2000? In the last 20 years, how have we done with the compliance rate?
We'll have to pull up the stats,
Just a second.
but it is significantly above 35%. We have a vast majority of people in compliance. Katie is going to pull up the numbers now. And we'll circle back with it, but far and away above 35%.
And then the other thing I would say is the gentleman that came and testified was a level 3, and it sounded like he committed a violent act against a 15-year-old and then kind of blew off registration. So he didn't comply and he didn't complete his treatment and he just wasn't in compliance. And so he was assigned a level 3. And to me, it sounded like the majority, if not all of his collateral consequences were a result of him not being in compliance and being a level 3. I'm not sure if that's reflective of the 18,000 people that are on the registry right now, but it feels a little bit like that one person's story was a little bit outside of what people normally do. So he basically said he didn't take anything seriously. He blew it off. He didn't do treatment. He tried 3 different treatments, finally did do the treatment. But as a lawmaker, I have a hard time taking that one anecdotal story, knowing that the majority of his collateral consequences had to do with being a level 3. And the reason he was a level 3 is because he was not compliant with anything that he was asked to do. Now, I don't know why he did that, but he chose to do that. So I just think when we talk about this, we should parse that out and think about the collateral consequences of being on the registry versus continually not being compliant and being assigned a level 3 and being deemed very dangerous to society.
I'll just speak to the speaker. I think so he went on the registry at age 15 because he had offended against a family member. And then he went through a series of treatments in juvenile housing and then he later had a statutory, he was convicted of a statutory, it was an age difference. And I think that's when he was assigned to level 3, and maybe he was assigned to level 3 when he was 15. I can't remember. So, and his level now is level 2. He's been downgraded because of his work and his taking seriously. So that's what I heard, is that he's now level 2 because of the work he's done. And I guess the other thing I heard is that the challenge for him is that he was a level 3, and so his name and articles and that sort of thing are out there, kind of living on the internet. And now that he's a level 2, he wouldn't be on the community notification, the public website, but he's basically on it still because of the articles that were published when he was a level 3. So I think we can confirm, but I think the level 3 came not because he was out of compliance or wasn't taken seriously. I think it was because of the statutory offense that he had later. That's what I heard. But you and I heard things differently, which is okay.
Angie.
Yeah, I was just gonna say the level 3 wouldn't have been based on only the juvenile offense because they can't assign levels if somebody only has a juvenile registration offense. And I think that's maybe why Brian raised his hand so he can speak to the risk levels, but it would have been based on both offenses and his other history at the time.
Yeah, that's exactly what I was going to do. And just what Angie said, just to clarify what Stacy mentioned, the risk level assignment occurs only as an adult is released from a correctional facility with an adult offense that they're registering for based on at least one adult registration offense, not solely based on the juvenile crime as Angie mentioned. And yeah, we look at overall history. We're going to look at past offenses, current offense, non-sex related violent offenses, treatment, chemical dependency, mental health, sex offense specific treatment. Were they on probation? How do they violate? Just an overall risk assessment. Actuarial scores, a lot of factors come into the assignment of the risk level in each case. So just to clarify that.
So just
Sure.
as a quick note in here, we have about 90% compliance. So up significantly from 35. The vast majority of individuals are compliant regardless of level.
Sheriff Heck.
So in reference to the speaker that we had, I certainly applaud his efforts to try to get back into under the right side of the law and be integrated with society and recognize the challenges that he has because of his behavior. I just wanted to point out that with him being included on the registry, even as a juvenile, I mean, he is the person that you want on the registry and his choices subsequent to that show. I mean, he didn't complete treatment, he recidivated. And I know that several people have noted it was an age offense. Well, that's still an offense, and that's still a victim out there that's been taken advantage of by somebody that should not have done that. And the other comment I'll leave is with that 90% compliance, the one thing I'd caution is what we're doing right now has had some success. 90% compliance. The study that was circulated by, I think it was Brian circulated about recidivism, noting that the fact that recidivism rates have dropped significantly. The caution I would put out there is the way the system is set up right now is working. So while we talk about ways that maybe it could be less draconian on those who are inside of the system, I just want to throw out there that we have a system that's working and we want to take care not to break that.
Stacy.
Oh, I was going to ask, did Representative O'Neill, I think you said it was a 35% compliance rate in Minneapolis because Rich Danik had testified at that time. Is that, so the 90% is in whole. Do we have just a direct comparison for Hennepin County or Minneapolis? Was it Minneapolis or Hennepin County? Do you remember, Representative O'Neill?
So Rich Stanek was the chair of the committee, and we had a Minneapolis police officer representing the Minneapolis Police Department. And I thought he had said that it was a 35% compliance in the city of Minneapolis, but I wasn't sure if he was actually, if he had a number statewide. I'm not even sure if it's possible to get a number specific for Minneapolis, but I do recall specifically it being 35%. And that was why they were considering the change from a gross misdemeanor for violating, so basically being non-compliant to a felony.
And I can get, to a certain extent, I can get the compliance number for now in Minneapolis. I don't necessarily know what we have in terms of at that time.
Okay.
And by I mean Katie.
Okay. Any others on this issue? Did you want to address the collateral consequences, the list that Angie?
Nicole,
provided?
I think, has her hand up.
Oh, there it is.
Thank you. Just a couple comments. One about the speaker that spoke about his experience being on the registry since he was 15. One of the things I did have some issue with is that he made a comment that because he was on the registry and he was level 3, like what motivation did he have to like stay law abiding and not reoffend, which I found problematic. And then he did reoffend and stayed on the registry or extended his time on the registry. So that was a little bit concerning to me. And I'm sure, you know, I work with programs that are working with victims across the state, and I'm sure that would be concerning to them as well. I do, however, think when we're looking at requirements for extending time on the registry, that it should be a registerable offense that would extend their time. I can understand the reason for, wanting them to remain lawful, but that could extend someone's probation without extending your time on the registry. I think that should be, it seems that it should be related to another registerable offense, because, for victims and people in the community who are looking at the registry, they are assuming that these offenses are sex offenses. And if they're not, then it's misleading to the community, because most of the community doesn't understand all the nuances of the registry. So I do, however, want to and plan to work with Ashley at Mincasa and send out a survey to our membership to get some feedback on these conversations as well.
Sheriff Heck?
Regarding the decision as to what should cause an extension of the registry, if we follow the logic of the registry is there to provide law enforcement with a list of people who have committed a sex offense, and also secondarily might be your suspects because they're continuing to display criminal behavior, I think it's logical then to say, well, if you continue to commit criminal behavior regardless of what that is, that's why we want to continue to have you on this list of people who have a sex offense and are continuing to participate in criminal behavior. I think that we want to, my thought is we want to be careful about, okay, is it important enough that it's a DUI, or should this just be held on to the worst of the worst criminal behavior? Well, if you're talking about predicting what people will do in the future, certainly not having any criminal behavior is going to be a good indication that they're going to stop it, especially if you can say, well, for 10 years, I've not done anything criminal. Well, I'd say that's a pretty good indication that you've learned and that you're not going to continue that. The question I keep asking is, so what is going to be that indicator that is going to say this person needs to stay on this list that's supposed to be for law enforcement to go access when we have to go look for a person that fits a set of circumstances in a sex crime?
Representative O'Neill.
Thank you, Sheriff. I'm going to jump right on the tail of that. So in my work in doing the test all rape kits, I did some extensive work and talked with the BCA quite a bit. And the interesting thing that we found correlations with, and they can correct me if I'm wrong, but this is my conversation with Superintendent Evans. They were seeing a connection between home invasion, burglary type cases, the DNA left at those scenes, and the rape kits. So I think we need to be really careful if we're going to start eliminating certain crimes, because we're not quite sure as we are now doing those rape kits. In fact, I had a conversation with Christina Warren from Hennepin County. She's a prosecutor that specializes in prosecuting rape cases. And they are now working their way through the 1,700 untested rape kits. And they are finding serial rapists that have lingered out in society for decades. And there are multiple connections. So while they maybe have just committed a burglary, they may have also been there for some other reason. So I think we need to be really cautious, just as the sheriff said, if we're going to eliminate some things, we're going to have to really think that through, because something that on the surface may not appear to be sex related absolutely has been proven through DNA that those are the same people committing seemingly unrelated crimes.
Angie.
Well, and I just want to reiterate, this is a predatory offender registry. It's not a sex offender registry. It was changed because it has kidnapping and false imprisonment and other non-sex related offenses. And that's what the legislature wanted on the registry, are these other serious offenses. So I just want to reiterate that. But from an extension standpoint, again, that those comments by Representative O'Neill got me thinking another idea might be, the extension maybe would only apply to felony reincarcerations for a felony offense. So maybe you don't limit it just to registration offenses, but you then don't include the gross misdemeanor DUI or the disorderly conduct or 5th degree assault or whatever. So that's just another idea, although the 5th degree assault might end up getting them under 243, 167. But anyway, that's just another thought, is it could just be the extension. It's kind of in between what was pre-2005 and post-2005.
Chris.
Thank you, Mark. And my question, I think, is for Angie. To the extent that how many of these crimes, such as burglary, have sort of been thought through already by 243, 167, as far as what would make them have to register again? So.
I'm sorry, can you repeat the question?
My question is 243, 167 has burglary is a part of that, right? So someone would have to re-register with burglary. Is that correct?
So if Katie, now maybe you might know this better than I do, but if they've completed their registration offense or never registered for an offense that they would have had to register for because the statute didn't apply to them at that time, then they commit one of the crimes against a person in 167, that's when they have to register under that. So it doesn't rope in crimes against a person generally for registration. Is that right, Katie?
Yep, well said, Angie. The piece that I like to point out is that you wouldn't be registering for a CSC case and then also the burglary because it's on 167, because it only applies if you've completed or if the statute didn't apply to you at the time of your CSC.
It would seem to me, at least, we have a list of crimes right there, at least the ones that are named, that we could start from and, perhaps incorporate and see if that would.
Oh, I see what you're saying. So you're
Yes.
saying maybe for the extension part of 243, 166, that list in 243, 167 might be a good list to start from. Maybe for those kind of convictions, apply that extension if they're incarcerated for those kind of convictions.
Exactly. Yes.
I certainly think that might be a good starting point for that.
Angie, maybe you want to weigh in on this. I'm just thinking about, at the end of the day, we have to, apply and try to, work with the current 18,000 offenders that we have. What about an inequity issue where, over the last 16 years, since 2005, we've been starting over for DWIs. What does this look like then when, Katie Myers restarted for a DWI in 2018, but Josh Floral doesn't restart for the DWI in 2022. Just want to put that, these are the kind of things that I think of sitting in this position here, and that I'm thinking you are probably thinking of representing us in the whole inequity thing is what I kind of like when I said, like, even the ability to plea bargain out registration, that whole inequity thing is what I really like to think of, because I see these and we answer these questions all the time when we get calls.
Well, yeah, and it seems like that would almost, if there was a change, it seems like that would almost have to be addressed, specifically people who are currently registering because of that kind of extension. Obviously, we couldn't go back and change what's happened where people aren't completed or whatever. But it's like, if there was that kind of change proposed, that would probably have to include addressing, anybody currently in those circumstances.
And I just want to say that would be a logistical nightmare here, just because, like, as you're asking for data requests, we don't say Hennepin County Jail connected to this offense. So I just want people to keep that in mind.
Nicole.
Thank you. Thank you, Representative O'Neill, for talking about like rape kits and all the many untested rape kits. I mean, and that's absolutely true. And the vast majority of sex offenders are not prosecuted. And so there are a lot of people out there that have not been, nor will ever be prosecuted, nor will it come to the attention of law enforcement or maybe not prosecution. And some of the issues too that also brings up for me is that communities of color and indigenous communities are overrepresented in the criminal justice system. That doesn't mean that we are the only offenders of these crimes. And so when we're thinking about, you know, all the consequences and the extensions and all of that, it just makes me think of whose communities are being most impacted by this. And that's not to say that I don't want, you know, offenders to be held accountable. I absolutely do. But, you know, I think we have a long ways to go before our criminal justice system has some equity and some balance in whose communities are really being impacted.
Okay, Stacy.
Back to the restart. I echo the idea that, you know, the potential exercise of going through the restart, the crimes, the convictions and incarcerations that would restart the 10-year period. You know, looking at felonies as the trigger as opposed to lower offense crimes. I want to make sure that people here understand what 243.167 is, because we've referenced that. Maybe for some of the non-lawyer folks in the room, Angie, could you maybe explain how 243, so the registration statute is 243.166, and then the next statute after that is 243.167. And Angie, could you just give the elevator summation of how 243.167 plays into 243.166?
Well, okay. I thought I did, maybe it wasn't, maybe it was too short, but so 243.167 references 243.166. And if somebody commits a crime against the person and they have either completed registration, so if they've completed registration under 243.166, and then 4 years later they commit a crime against the person, a 243.167 crime, then they have to register again. And then the other way that 243.167 is triggered is if, let's say, before false imprisonment was on the registry, somebody had a conviction for a false imprisonment, but they didn't have to register because it didn't apply to them at the time. And then later on, they commit a crime against the person. They then could have to register under 243.167 because they were never required to register in the first place, and now they committed this crime against the person. Katie, is that right?
And for Minneapolis compliance, Katie was able to pull that up. Right now, it is sitting at 84.82% compliance. Obviously, that will change day to day, hour by hour, but that is where it sits right now.
And just to clarify that the earlier thing, Angie, the restarting the registration that expired or starting it for the first time if it didn't apply only applies to convictions for registration offenses. It doesn't apply to past same set of circumstances. So that's a little bit of
Correct.
limitation on 167. So.
That's correct, yeah.
Yeah, it doesn't account for same set of circumstances, and it also does not count towards a lifetime registration. It's not considered like a all of the offenses under 243-166, a second conviction would result in lifetime. Those, what we call a cap offense, the crime against the person offenses, those are a 10-year registration period, subject to the restarting, but not a lifetime.
Chris,
And one of the advantages of this list, as it's laid out, as crimes against the person are defined, is if we were going to make a blanket statement that it was just felonies, for example, or felony level offenses that would require renewal of it or another 10-year period, I think most people would probably think that domestic assault or fifth degree assault, which oftentimes are misdemeanors, are violent acts that probably should be included in continuing that 10-year period, as opposed to something like a DWI, which seems totally unrelated. And this list in crimes against the person includes those. So it would include misdemeanor level offenses, gross misdemeanor level offenses, and felony offenses. But it's basing those basically on it seems to me, whether or not these are violent acts against another person.
You have a handy list of cap offenses that Olivia can send out, and if not, I can put something together. And I feel like you have one.
Yep, I'll send it to her right now.
Okay, thanks. Because you
There
go
are
to
a
the
couple of-
statute. Oh, I was just gonna
Go
say, if
ahead,
you go to
Angie.
the statute, it's all linked to the statutes, and it's really not very user friendly. So if we had a list of what the actual offenses were, I think that's easier to see.
Yeah, and there are a couple of offenses that the indecent exposure and the criminal sexual conduct fifth degree are on there at the gross misdemeanor levels on those cap offenses.
okay, Sheriff Heck.
If we start considering, cap offenses and start eliminating some of these misdemeanors, and I know we've thrown DUI around a lot. I think that we want to consider, okay, so what are some of the lower but included offenses that a person might plead to in, for example, a domestic abuse scenario, where we would want to capture that original offense, but that lower offense that they might plead to would be not included. I frequently see domestic assault arrests that are pled down to disorderly conduct. I don't think that we will, I think if you ask people if that person who has the domestic assault arrest and incident where they violated the law against their partner but pled down to a lower included offense should still be required to register, I think most people would say, well, just because they plea bargain doesn't mean they should not be considered dangerous on the registry.
Patty,
I have a question, since this is one that keeps getting thrown out. Domestic violence is absolutely horrific, but I get confused by predatory offender. Basically, those are situational, and I think it needs to be dealt with in the strictest form. But a public registry, is that what it was designed to do? And they're not likely, maybe I have my stats wrong, but it doesn't appear to me that they're out there kidnapping other people and assaulting randomly or whatever. It's a horrific crime. I'm not minimizing it, but is that what should be on the registry? I'm just a little confused about what is our purpose with it and who should be. And the other thing I have to say, since you called on me, I still am going to always say that the criteria, the mind development of children, is how many parents have said, I've told you over and over again, and you keep doing this stupid stuff. Kids are like that, and I just think they need to be dealt with with different criteria rather than taking the adult mind and the adult behavior and applying it to children. So I just think that needs to be a special consideration as we go forward. But I guess my broad question today is, I heard somebody saying that the predatory offender registry is not just sex offenses, it's predatory, and I'm just a little confused. But that's
So just a couple of things. We do see a lot of overlap with false imprisonment and domestic violence. And so a lot of those crimes, for example, are together. They are part and parcel. We see a lot of domestic violence victims being held against their will, either in a location or with an individual. And so those kinds of things are not, they end up being linked together. So we just wanted to give that as an example as to why some of these crimes are on the list, because there might be a situation where domestic violence in and of itself may not be charged out. However, there is enough evidence for the false imprisonment, et cetera, and vice versa.
Nicole.
Yeah, I was just gonna speak a little bit to domestic violence, and you know, many times an offender of domestic violence will, you know, when they get into another relationship, will commit the same sorts of offenses. So it's not like it's only an isolated incident. And also, you know, sexual violence, oftentimes the victim is known to the offender. And so that very many of the same dynamics are present in both situations. So I absolutely see the connection. I don't think it's just like an isolated thing that only happens because this one victim and this one, you know, offender in a domestic violence situation. I don't think that's the case at all.
Sheriff Hack.
So when we're talking about, again, this registry was created to be private information for law enforcement to go to find suspects when we had a case that was unsolved. The people that are going on this registry are going onto this registry because somewhere along the line, our legislature said, you know, we think there's a likelihood that these people correlate with a group of people that could carry out these predatory offenses or sex offenses. And just again, my layman, I'm just a cop, logic says, well, if you've done it before, if you've falsely imprisoned someone before, that is an indicator to me that you likely could do it again. And I think that's a broad net. And there's certainly going to be some people in there that, well, because of whatever is going on in their psyche, they will falsely imprison a domestic partner because of the dynamic going on there, but maybe, you know, they wouldn't necessarily go out and do that to a stranger. They wouldn't necessarily go and do that to carry out a sex offense. My question, though, as we talk about changing this is, who is going to have the wisdom of Solomon to separate these people out and say that, okay, you who have done this one time on a domestic, we know we can look in the future and say, you're not going to do this again to another person. You're not going to commit a sex offense and hold them captive. Who is going to be that person that is going to split that baby and make that call?
Okay. Anything else here? Patty.
I hear you and I agree with what you're saying. My challenge is, are we casting such a broad net that, especially with notification 3 and on that website, that we are that the general public is under a different perception than what we know to be a reality. We're putting everybody, and the perception is they're all sex offenders. You know, once you've done it, you're going to do it again and again and again. And I think that we need to be use a little bit of caution, especially with extending it repeatedly, because our hope is that these people who've done these horrific crimes will stop if they're meeting these criteria. So I don't know the answers. I do hear you, but I think it's just broadened so much from when it was started, because you're right, Sheriff, it was started as a law enforcement tool, but the openness to the community really changes so much. And I'll be quiet now and listen, but I have concerns about the broad net of what we're talking about.
Sheriff Eck?
Indeed, and yes, Patty, I understand your concerns and I hear where you're coming from. The one thing that it causes me to think about is, again, this registry is supposed to be for law enforcement. And it sounds like, I know I've said this before and I'm in a lot of these meetings, so if I've said it here, forgive me, but it sounds like a lot of these collateral consequences we keep talking about happen because of the notification law and not the registry law. So if it isn't necessarily, if the problem is not that law enforcement knows about these people, but the problem is that the public knows about these people, or this kind of scarlet letter that is developed, maybe that's what the focus needs to be on. And maybe the legislature needs to roll back some of this access to the registry that is not law enforcement.
Stacy?
Yeah, I think, the community notification on level 3s and out of compliance. I from a legislative standpoint, I don't really see that. I mean, that seems to me like a heavy lift. Certainly people want to know when a level 3 has moved into the neighborhood, right? And that's a legitimate, I mean, it seems like a legitimate, thing that as a, person living in my neighborhood, I'd like to know who's down the street, right? That's seems reasonable. The collateral consequences that Angie sent out, which is really helpful, Angie, thank you for putting that together. These aren't on the notification side. This is just being on the registry. So there's a difference. There's certainly a major difference between community notification and just then being on the registry. On the false imprisonment stuff, I'll just say I've seen, a lot of cases, and I think Luis touched on this when he spoke last week, which is false imprisonment is, oftentimes a, charge that's put along with domestic assault. I mean, I have a client where, the person showed up at his house and was demanding certain things. And then there was an incident and he was charged with domestic assault and false imprisonment when she was trying to take something and he didn't want her to take something and he didn't want her to leave. And so he was charged with false imprisonment and domestic assault, pled to the domestic assault, the false imprisonment was dropped, and then he was on the registry. That's just one situation. And of course, I certainly appreciate the domestic assault. Crimes are very serious. And to someone's point, if it happened within one relationship, it's, very possible to happen in another just because of the nature of the person. I think that was you, Nicole. But I think there's those situations where false imprisonment, to the extent that there's probable cause, but not enough for the prosecutor to really hold them on it, that we need to be careful about those. I just want to get back to the restart though. There's a couple ways we could skin that cat on the restart. Maybe it's the felonies only, or and looking at the crimes of person is a good start, like Chris suggested, in 167. And then, maybe it's, maybe the restart isn't another 10. Maybe it's, something else. Because if you've got a person in year 9 or year 8, or even halfway through, getting another add-on, it's still significant. It's a significant, requirement on the registrant. But it's at least reducing the net a little bit. being a little bit more thoughtful on Nexus. So I'd be interested, yeah.
I really just want to bring up the fact that we have an automated system that does these calculations. And so if there is any change to the time or the crimes, again, we're going to face the equity issue of how do we go back through, how do we handle these individuals? At what point does somebody stop or restart or begin? And so I do just want to bring that up as we're talking about these, as it is going to have an impact to implementation and what we are going to need to be able to make things the way that you want them.
Sure, and I appreciate that, Olivia. I think the bigger question is a policy issue. So, we, as a state, we make policy decisions and then we figure out ways to implement them. And certainly retroactivity is a huge thing and implementation is a huge thing. But I think the threshold question is, what is the policy? What policies do we want? And then, if we decide, based on values, driven, decision and that sort of thing, that, the policy needs to be this, then we can go to the next level, which is how does this actually work? So I certainly appreciate the implementation from the BCA side is, a challenge, but I don't think that's a reason that we would say, well, we just can't do it. It's too hard. And I'm not
So
saying
I do want to clarify that that's not what we're saying.
No,
what we're saying.
Yeah, I guess what I'm trying to get us back to is the policy question and the values question and the original purpose of the statute question.
Angie.
Well, so my question may be stupid because I know no question's a stupid question. I was going to ask from that standpoint if there would be some kind of way to evaluate it at annual review, but that's still a lot of offenders, because I think it averages like 50 offenders a day if you divide the 18,000 by 365 days, and that's not even counting working days. And also our annual review, are those letters all automated, those verification letters, Katie? Is that something that's individually looked at?
Yep, there are automated, and we do not typically do reviews of each and every case each year because of the automation of things. So those would all be processes that we don't do. And by no means are we trying to stifle the policy conversation. We just want folks to be aware of the impacts and the implementation that this will have. If that's a decision that folks want to make, by all means. But we want to bring it up namely because of the amount of time it is going to take in between the policy decision and actual implementation for everyone.
And I know we've talked about this data a million times. Is that something that we have or getting data on how many are under those kinds of extensions?
Go ahead.
So because of system updates over the years and because of the historical nature of the data, just like I'm saying, we cannot go back and add in everything. Like when you make a change, we're gonna need it to go this day and forward, whatever. What happened over the years is as we've updated and changed systems, different systems have allowed us to put different information in. And so the idea of my first initial thought was to say, okay, show me every offender who just has more than one registration period. Well, that doesn't work right out the gate, because when we built the new system in 2014, everybody got a whole new registration date. So we can't exclude. Other things have happened where if somebody changes the date, sets it back because somebody was successful with the Court of Appeals decision, that individual is going to look as though their registration period restarted when really it didn't, because they had a successful court case. The data is just not stored or tracked to keep to provide statistics or information with a lot of these requests. Sorry, that was a super long roundabout answer, Angie, but we can't come up with, I've tried, and everybody that has tried to help us, you just could not get it with 100% certainty. And if I can't give it to you with 100% certainty, I'm not backing it.
Brian,
I just wanted to jump in again about kind of the off-ramping part of the whole thing. Stacy mentioned, policy change, which would this could apply to. And then the implementation would be another question, as Olivia brought up, in terms of resources. How would we actually go about doing this? I keep going back to the idea of risk assessment. Right now, me and my unit of 5 psychologists could not be able to handle something like this. But the idea of what's common in over the last couple of years is this idea of desistance or time of free effects for men and women who've committed sex offenses. There's actually empirically validated actuarial methods to look at if they've been in the community for 1 year, 2 years, 5 years, 10 years, how has their risk lowered? That also incorporates additional offenses, non-sex offenses, just misdemeanors, gross misdemeanors. They kind of get a backup on the lowering of the risk overall if they continue to commit other non-sex related crimes. But if they've gone crime-free for 2, 3, 4 years, there's actually a chart, and they just came up with a time effects-free calculator, actually, that can calculate a few of these things. So again, the process by which that would happen and the resources is a question for down the line, but there is some availability, empirically validated ways to assess current risk after somebody's been in the community for a period of time. So just as a way to, I can send some of the research and information out to the group, to Mark and Olivia after this, if people are interested.
Katrina.
Thanks, Brian. That was helpful. I agree with Stacy in regards to just in general about the policy. I just have a general question. So if we are looking at changing a policy, just so I'm clear, then we are only looking from this point forward, retroactivity isn't possible. Is that correct?
I mean, no, that what we're saying is that retroactivity is going to take a heck of a lot longer than we're looking at, because the policy change in and of itself is one thing. It's the implementation of that policy change that is going to take time, because we need to find a way to go through each and every one of these preset and pre-timed people, and either do the math, not do the math. All of these things require one person to look at everything.
Which is why we can't
Which
supply
is-
that data.
Which is why we can't supply the data right now in time for this working group, because we simply don't have the staff or the time to do that.
Okay, Stacy.
Slash, the data may not be tied, I'm sorry, because we're also talking about somebody's criminal history. So then, as opposed to us just getting the notification that there is a triggering event, we now need to look back at somebody's criminal history, decide what does and does not qualify, and then do the math from there for each and every individual. I don't know if that makes sense.
Thanks.
Okay, Stacy.
So I did a data request that Katie, you helped with back in 2020. The request, I think, was the total number of people whose registry time of 10 years, so this wasn't lifetimers, whose registry time of 10 years has been extended beyond the original 10 years due to either 1, a failure to register, or 2, because they were convicted of another offense since 1991. So I asked for data since 1990, or you provided data since 1991. Basically, how many people have restarted? And I think, and the number came out at 12,308. And so that would be out of like the 18 or 19, whatever the day of the number of registrants that day. It was 12,308.
So that would be for all time. And so that would be the 35,000.
Okay.
But Katie.
Yep. And Stacy, to speak to that, and I think that we have had this conversation out loud either in this group or in another group, that again, when trying to do, provide the data this time around, Stacy, it was discovered, like I said, that system update where everybody looked like they had been restarted. There's additional people that looked like they had been restarted. That same poll I cannot give you today. I wouldn't be confident in that number at this point because of the system and the way these updates have happened over the years, that we're just not set to track it that way. We can see failure to registers, but that's only as good as what we've been given by the offenders, by the courts. We have a caveat in the verification letters that say that, your registration period is subject to change based on a period of incarceration. Well, if they're not forthcoming and we find it at the time of review, we have to add that 5 years. So, what we pulled for you could be more, could be less if it was that updated, because of a system update. We just can't with 100% certainty. I'm telling you, I've lost hours of sleep based on this data request. I've racked my brain on how we could accurately pull this, because it's just not what we were instructed to do. I could give you any number right now, as I just did. We've given you the overall compliance rate. We've given you the compliance rate in a particular city. We can give you what the legislature told us to track and provide for law enforcement. What we can't give you is all of these extra caveats that are individualized to an offender. Right now I have 7 employees. I've got 1 out with cancer. I've got 2 brand new employees in the last 2 weeks. 1 person's training. We don't have the resources to look at 18,000 files and say, oh, yep, this offender meets this. We just can't do it. And like I said, we gave you that number a year ago. I can't fulfill it again this year.
Yeah, and I'm actually, I appreciate that. And I appreciate the fact that the registry wasn't set up to collect data this way. And so when we make data requests, I think the hope is is there this data out there? And if there's not, there's nothing to do about it today or, this week or anything. I think it raises a interesting question of, should we be tracking data in a different way? But that's a separate question. So I appreciate that what the registry is designed to do is not collect data this way or organize it this way. It's designed to just track offenders, right? So I get the challenge that you're facing when we put in these data requests. The curious thing about the working group and the charge from the legislature was we have 4 months to examine the data and study it, examine other things, and then make recommendations. And it's a pretty heavy lift when we don't have data. And again, I'm not pointing a finger at the BCA saying, why don't you guys have the data? You just don't. It's not how you were set up. So I get that.
Patty.
Yeah, I'm just gonna bounce off of Stacy's comments and the BCA and Sheriff Heck. This sex offender registry was designed to be something completely different than what it's evolved to, in my opinion. And our system, the system that was set up to track offenders, sexual offenders was what it was for, is not able to do what we're asking of it today. So I would suggest that if we want this, that we have to build that into a recommendation to the legislature. We have to create what it is that we want or need from it, and then build a system so that we can address the needs of both respectful of those who have completed their requirements and are off, and those who have done minor offenses and got extended, and just the caveats, the things that we've been talking about for almost 2 hours would need to be addressed going forward. We can't go back, and these guys have been amazing at the BCA and what they've been able to do with what we started out with back, I'm just going to say 1991, we decided we should have sex offender registry, and and created something that is no longer meeting the needs of what we're asking of it today. And I also want to just say that there is a false, Nicole said it, most offenders don't ever get convicted. So the general public, we're taking a very small sample of all of those who've committed sexual crimes. The general public is believing in whatever it is, whatever data we put out there. So I think there's a responsibility to collect what it is we want and bounce off of Brian's knowledge of those who are in the communities and don't reoffend it in these manners. These got the criteria, are less likely to be of a threat in the future. Law enforcement could keep it for longer, just like they keep traffic records of how many times you've been pulled over forever. They don't go away. But the general public needs to know that some people do move forward, and there has to be a way of addressing all of this. And I believe the BCA needs to have permission to build something that can more easily answer the questions that we're asking of it today. We need funding for that, I know.
Angie.
Well, and that's just kind of what I was going to say is if this is something that from a policy standpoint, this group proposes to have it be only felonies for the extension or to have it be the crimes against the person list or something similar to that, then I think that as part of the report, we also put out there that what we talked about before, we don't have the funding to get, we didn't have the funding to get all this data. And the BCA, there is this equity piece, and if it's from now going forward, if it's something that the legislature wants to look back at, then the BCA would need a bunch of funding for that. So I think that's something that we need to let the legislature know. We think this is a good policy thing, but these are the kind of other issues that it brings up.
Representative O'Neill.
Well, I was going to say just what the last couple folks said. I think it's really important for the legislature to know the things that this database cannot do. And if we need to build a different database to be able to track information differently, then that could be one of the top priorities to send back to the legislature as a report, that it's very difficult to do the work when we don't know the data. So I would encourage you to have that as one of your top lines back to the legislature to create a database that is user-friendly and that we can pull out this information. So I agree with the last two. That's really important.
Okay. So again, we have that the extension of registration periods was part of the work group. We haven't really gotten to the collateral consequences list, and that would include both the statutory ones that which are state authorized collateral consequences that Angie provided that list. And then there are those collateral consequences that aren't state mandated, such as, and the big example that was brought up by Superintendent Evans at the very first meeting was the residency restrictions, that there are lots of questions about that, where it includes, and I think there's a misunderstanding on this, that it does include registration status in some of these ordinances. And because the ordinances aren't state authorized or state regulated, there's no consistency on them. So some of them, a great number of them, only apply to level 3s who are subject to broad public notification, but some of them also apply to people who are simply registered, and a limitation on those numbers. Anything else, Angie?
I was just gonna say from the ordinance standpoint, I think we talked about this before. I mean, we have no control over local communities, but I think we could, as a policy recommendation to the legislature. I mean, I think Representative O'Neill said, that is something that the legislature could restrict those kinds of ordinances if they want to. But certainly we don't have much control over what communities do otherwise.
Representative.
And it's
O'Neill?
certainly, I was gonna say, but it's certainly something, again, that we can take into consideration from the standpoint of, should somebody with a disorderly conduct stay on the registry? You know what I mean? So.
So, yeah, I've been a part of a lot of those conversations at legislature. Been on the Public Safety Committee for 9 years. And so I think what the legislature would want to know is the effect on safety. So if concentrating sex offenders in a particular area because ordinances have restricted them out of others, if that actually is in opposition to public safety, if it's not actually creating a safe place, then I think that's something that the legislature needs to know. But I don't know that we can see that because the database can't give us that kind of granular information. So I'm not sure if we're quite ready to present that case to the legislature because we simply don't have the data, because the database wasn't designed to give us that kind of data. So we still kind of come back to maybe we need to rebuild the database and have better information, because what the legislature is concerned about is public safety. And so if public safety is better by eliminating those registry restrictions, then they'll listen to that, but we have to demonstrate that.
And what I do want to bring up just as we discuss this is that if folks need a moment in time, there was also the discussion about a study to hold over, especially considering implementation of some of these things can take significant periods of time. And I believe that was something that Representative O'Neill had brought up before as well. We are still going to have the issue of back in time, gathering that data. So know that as we're discussing these changes, it's going to be moment in time forward.
Okay, Patty.
Maybe Mark or Brian will remember, but I thought years ago the Department of Corrections did a retroactive study of sex offenders and how where they lived would have impacted where they committed their crimes. Do you remember this? And I thought that of all of the cases they studied, there wasn't one where it would have made a difference. And that being said, because we're such a mobile community, so, Chanhassen, for example, or Victoria or whichever city out there voted to not allow people to live there, doesn't mean that they can't, somebody driving through can't go there. It just, there's a lot of research on this, not necessarily in Minnesota, but how it's impacted people across the nation. So I think that we don't have to redo that, but I know the Department of Corrections put something out years ago on past cases.
Yeah, I can speak to that, Patty. Yeah, I was looking up another study related to concentration of men or women who've committed sex offenses in neighborhoods in Minnesota that the department completed in July of 2015. I'd have to refresh my memory on kind of the key findings on that, but speaking to what Representative O'Neill was talking about in terms of concentration of people living in certain communities and things like that, we have some data on that. But regarding what Patty said, yeah, I believe it was 143 guys. They looked at a large number of men who had committed sex offenses who were released, and then 143 or so of those had reoffended sexually. And they said, had residency restrictions been applied in those cases, how many reoffenses would have been prevented based on those residency restrictions? The answer was 0. They were all social proximity. It was a neighbor, somebody they met through the social connections. If there was, I believe, again, I'd have to look at the specifics, but if there was somebody that committed an offense against a stranger and abducted somebody in a park, it wasn't within 1,000 or 2,000 feet of their home. It was traveling to another community, that kind of thing. So, not just Minnesota, but there's other research available that has shown for a while now that residency restrictions do not increase public safety whatsoever. My unit goes out and talks about that exact data during community notification meetings and kind of public education about when cities are going to enact these ordinances. We talk about how it's not a good idea. There's no research to say it increases public safety. It actually destabilizes guys and can increase their likelihood of reoffense because they're limited housing and limited employment and limited relationships. And so it's actually having a counter, the opposite effect in many cases. So I'll look into that concentration in Minnesota neighborhoods, study a little bit more, and can send that out too.
Stacy.
So Representative O'Neill, would the research that Brian and Patty have cited, would that be sufficient or compelling enough to bring to the legislature on the residency restrictions issue?
Possibly. Like I've been there almost a decade, and this whole topic might be one of the most controversial there. So we have had that conversation. Now that he said that study, I think that study was cited and no changes were made in 2015 or 16, somewhere in there. If you want to change done, we really have to have our ducks in a row and have good data to support it. Data that shows these changes will increase public safety. And so I'm just letting you know, it's a very, very difficult, a very controversial thing at the legislature. And, we harken back to Jacob Wetterling's case, and I'm glad Patty is here because her voice can be very compelling, to Drew Shadeen, all these things that were put in place. I think what the legislature needs to understand is this was put in place when law enforcement didn't have really any tool at all to cross-reference databases. And we have come so far since then. There are, the databases are a lot better. They're not perfect, and they don't speak to each other as much as I would like. But nonetheless, they're a lot better than they were with Jacob's case. So in making an argument to the legislature, it has to be very compelling, multiple points of data to show that these changes will increase safety.
So I think if I can just follow up on that then, so that's really helpful to hear. So when you say that the changes need to increase public safety, so that's a slightly different lens, if you will, of saying residency restrictions don't improve public safety. Do you see the distinction I'm talking about? So we can say, we think that the legislature should make residency restrictions unlawful, or somehow make that unlawful because it will increase public safety. I don't know that we could ever get to that point because I don't think that's the way the studies have worked. I think the studies have looked at, from what I'm hearing, and I haven't looked at them, but that they don't improve public safety. And in fact, they may even negatively impact public safety or reduce public safety. So it's what side of the coin do we want to look at? And I just want to make sure I'm understanding what you're saying. Like, is the legislature only going to be able to hear, we just want improvements in public safety? Well, I guess you could say it's not an improvement in public safety if it's negatively impacting public safety residency restrictions by shutting these people out because they can't integrate and get socialized. And it's a bona fide we know it doesn't improve public safety, because if the offense is going to happen, it's not going to happen because if the offense is going to happen, it's going to happen regardless, and a residency restriction isn't going to stop it.
So I think what's compelling is what Brian just said, which is if you want someone to stop molesting our children and raping women and holding people against their will, that if you help them to make positive changes in their life, so I've also been the author to expand drug and treatment courts across the entire state and fund it. And the reason that's successful is because it holds people accountable. They have a weekly time they come into court. They have to have a job. They have to have housing. They have to go to their meetings. They work on their sobriety. They work on not having criminal behavior. Those things we know work. And so what Brian was just saying about if someone has committed a crime that would land them on the POR, then our goal as a society is to help them to stop the criminal behavior. And the factors that help stop criminal behavior are stability in that person's life, stable housing, stable job, a safe social network where they don't have temptation to offend. The things that Brian just said, those are the compelling arguments of the legislature. Those are arguments I can make at the legislature. So when I'm talking about what makes the public more safe, they're more safe when criminals stop being criminals and they reintegrate back into society and are law-abiding. Quite frankly, that's the whole point of the whole system, is to help people and keep them accountable, but encourage them to be law-abiding. So that's what I mean when I say if we're going to make changes to the POR, then there has to be movement in the direction of this is how it's making the public safer, because the likelihood of reoffending is reduced.
Okay, so what I hear is the headline is any changes to the POR that are being suggested will improve or increase public safety. And we know that because of these studies and these studies. So that's going to be the headline, but it may be the negative that we're proving instead of actually proving the positive, if that makes any sense.
I mean, sometimes you have to demonstrate that the actions that the POR is taking right now is making life so difficult for someone that they either give up or it just isn't working for them to change their life and to choose a different path. And I think Brian probably has been very articulate in saying that, and he's got the psychological training to explain that and to say that. And so I was sort of trying to point us in that direction.
Yep, totally understood.
Nicole.
And I was just going to say, I mean, the reality is that we all have probably sex offenders in our neighborhoods that we don't know about, right? And so when we're thinking about these, residency restrictions, there are countless sex offenders that we don't know about because they're never going to get on the registry. And so, it's great that there's a tool to be able to know about some of them, but, I think in some ways it's created like a more fear. And then people forget that there's many more that we don't know about that are probably their neighbors.
Angie.
Well, I'm just kind of piggybacking on those comments, because there are so many unreported offenses. I appreciate the fact that the recidivism rates have gone down according to the studies, but those studies only have the reported offenses, or they're based on arrests and convictions. So they're regularly considered underestimates. They're for a limited time frame. People are observed. Static 99, I think, is 5 years and 7 years. The MinSOST 4.1, is based on 4 years and has to be a reconviction within 4 years. So I think that we have to take into account the limitations of that data too, as far as the straight numbers are concerned. And that's something that Janine was talking about or had mentioned last week, and we talked a little bit last week, but I do think we have to keep in mind that there are other, a real risk assessment looks at a lot more than just actuarial tools and statistics.
Okay, and then Representative O'Neill.
Thank you. I just had another thought too. We've been talking a lot about, for example, DWIs, but I would ask Brian if he could kind of speak to the correlation between actively not being sober, I don't know, falling off of the wagon, so to speak, and criminal behavior. Because what I've seen is if you look at those that are in our system, in the court system, 85 to 90% have an addiction issue. And I know the person that came and testified said, when he was actively involved in his addiction and not sober, that he had more criminal behavior. And I'm wondering if you could just talk about that correlation between addiction and sobriety and offending.
I mean, I guess it's not my key area of expertise, but having done just risk assessment in general and working for the department for many years, we do see a large number of guys that come to prison with chemical dependency issues. And again, anecdotally, I don't have numbers here, but I think a big chunk of those guys, you can point to the chemical use and dependency as one of the key factors in committing future criminal behavior. Sometimes sex offense specifically, there's guys I've seen where every time they offended sexually, they were drinking and using. Maybe they wouldn't have necessarily. But then there's other guys that were completely sober, and it was based on more of a kind of a deviant sexual interest in children, had nothing to do with chemical dependency. So again, I think the general rule is the guys that can stay sober and are just going to be healthier, live much better, more successful living a crime-free lifestyle. But there's, again, go back to individual cases and individual risk assessment is going to be the key piece. Again, that's a implementation and resource issue and in terms of how we'd actually do that. And I agree just what Angie had mentioned too. I bring up actuarial instruments a lot. She mentioned the MinSOST, and I talk about the static 99R. These have moderate predictive accuracy. So if we're just using those numbers, a guy scores into the well above average risk for sexual reoffense. Well, a handful of those guys are not going to reoffend sexually. They just fall into a group of guys that, based on risk factors, are more likely than guys that score lower. Unfortunately, sometimes there's, we assign a guy a level 1, he goes on to reoffend. We assign many guys level 3s that do not go on to reoffend sexually. So we're doing the best we can with the best science available. It's predicting human behavior. It's a difficult thing to do. And now I'm just kind of going off on tangents here. So I hope that hit on a little bit of what you were asking, Representative O'Neill.
Yeah, that was really helpful. I just think it's important to understand that if someone is actively in their addiction, that they are more likely than not to fall back into criminal behavior. Thank you.
Nicole.
I think the other connection, particularly with addiction and chemical dependency, is that oftentimes people develop addictions because of underlying trauma, oftentimes sexual trauma. And so, the connection to previous victimization themselves, which then contributes to addiction and numbing. And so I think it's all very connected and related, and also, points to, separate from this issue of the predatory offender registration, is that, with chemical dependency treatment, we need to get better at addressing all the underlying traumas that keep someone in their addiction.
Okay. Okay, we have about 12 minutes here. We wanted to give an opportunity just in case any of the public observers wanted to make comments or have questions. But we still have a few minutes here. Anything additional before I recognize any other? Anyone else on the working group? Okay, I'll open it up. Brad, did you have something to say?
Yes, thank you, Mark. And I appreciate everybody's work and diligence on this. And I just wanted to bring to the attention of those who maybe didn't have an opportunity to kind of focus on this. In the registry statute is subdivision 4B that does require notification of various healthcare facilities as designated by the statute of a registrant regardless of their risk level. And we are seeing in a practical way on the ground, as you will, where we have an aging population of registered individuals who perhaps are level ones at that lower tier of recidivism risk, who are now being denied critical health care because of that component of the notification, or I'm sorry, the registry that says notification is to be made regardless of risk level to all other clients or people's being served within that healthcare facility. Just wanted to put that out there as a topic if it has not already been covered. Thank you.
And that is actually one of the statutory things on the list that Angie provided, was that notification to healthcare facilities. Anybody else among the public viewers? Any last word? Yeah.
I was just going to say on my list, that's actually a separate statute. So there's the requirement in 243-166 saying that health facilities have to be notified of their status and give notification as required under that part of 243-166. Then there is, in the Commissioner of Health statutes, 144A-135, there's a separate statute that says a person who fails to inform a healthcare facility of their status as a registered offender is deemed to have endangered the safety of individuals in the facility. So it's kind of a separate, I don't know, maybe it's meant for like an enforcement of that, a civil kind of enforcement of that, but just so the members know there's a kind of a separate statute on that. But I think the issue more is, how helpful is that notification statute? I mean, I again, not looking at legislative history, I imagine it's to protect vulnerable patients in those facilities. And again, should that be, restricted more by type of offense they're registered for? I don't know. But without looking at the history specifically, I'm just sort of inferring that was the reason for it.
I'd like to say too, I think that data, and Brian, correct me if I'm wrong, but what that admission needs to be made when they're brought in, but then the amount of information that is shared thereafter is dependent upon risk level, and who that information gets shared with is actually people that are receiving care, not the employees. That there was a concern over the years. People have called and asked, they've had employees working in these facilities, but the statute is very clear as to who actually gets that information, when they can give the information beyond just receiving what they receive from law enforcement. But what they can actually do with it is pretty limited if the offender is subject to that notification in the facility.
Yep.
And I think if anybody to clarify, I think Brad or Mark could actually do a better job of that piece of it, Katie, if they need to, but otherwise it sounded like.
Sorry, I got the wrong B. It was Brad, not you, Brian. Sorry.
Oh, there we go. All right.
Though you are equally important and valued.
Thank you.
Yeah, and Katie is correct on that the broader notification to residents of the facility is only for those designated as a level 1, 2, or 3. And they're all the same, treated the same. And then for those without a risk level, it goes to the facility administration and they don't have to share it with all residents.
They actually can't share it.
Right.
So it would be illegal for them to be sharing that information.
So Mary Cardinal Peterson.
Thank you. And I first want to commend the group. Great discussions, great questions. I really appreciate having the opportunity to listen in and contribute. And back to Representative O'Neill's point regarding the correlation between chemical dependency issues and recidivism, that is really important. And before looking at saying misdemeanor DWIs and or drug offenses aren't a concern, as a former probation and parole officer, the people who I supervise, the sexual offenders I supervise, the ones with those chemical dependency issues were the highest risk on my caseload. And they were, if they were picking up DWIs or misdemeanor substance, possession offenses, that was telling me they were still at high risk, and that was something to watch. And Brian, as you were talking about, the information, yes, it's true that not all people chemically dependent offend, but the ones that do are concerned. But I don't know if it would be helpful to look at the people as from the end of confinement review committee assessments, to look at how many of them do have chemical dependency issues to decide if that's something to consider in your recommendations or not. So that was one piece. The other piece with the collateral consequences with, yes, residency restrictions is huge and egregious, but also with the public information, the fact that people are required to register is, my understanding still is by statute, private information. But how people get by that is landlords, landlords often will ask the people applying, are you required to register as a predatory offender? If they're asked that question, they can't lie. They're going to have consequences if they lie too. So there are several incidences I've come across that landlords are, their conditional use permits or their insurance policies are dictating that they can't accept people that are required to register as predatory offenders. I don't know the answer to get around that, but it definitely really increases the amount of collateral consequences, because they can't lie, because they have consequences if they do. So those were my comments. Thank you.
Chris, did you have a response?
Oh, no, I just wanted to say, I think that's a great point on the, private landlords or property owners having these restrictions. And I know the list that was sent out indicated that it wasn't exhaustive, but indicated there were 92 communities, counties, and cities that have residency restrictions in effect in Minnesota. And I just wanted to say that that is in fact extremely small number when you're looking at total counties, cities, and townships in the state. That's approximately 2,800 local units of government that could put these in place. So they're not particularly common. So the point related to private restrictions is well taken, I think. So.
Okay. So any last words from our chairs or from Olivia before we?
None from me.
Nope.
Thank you, everyone.
Yeah, thanks, everyone.
Thanks, everyone. Have a good day.
You too.
So long.